This case opens with immediate red flags. The court is reminded that Ms. Gibson has already been found in contempt for financial misconduct, and there are even concerns about altered documents.
In the home sale, and there was a cleanup one that had never been entered from May. So I'll address the home sale one first. There should be an order regarding home sale. Ms. Gibson filed objections. The only thing she's really objecting to is I'm asking for the home proceeds to be placed in my trust account. She wants it to be placed in essentially a bank account with both their names on it. That's just not appropriate. It should be a significant amount of funds. Ms. Gibson's already been found in contempt for financial misconduct in this case. Second, based on material she's previously filed, there are concerns whether or not she has fraudulently altered documents, again, leading to quite a bit of concern on what she would do to access those funds. She doesn't provide any other basis for putting it into a sort of traditional bank account instead of an attorney's trust account for safekeeping. There's just no reason not to protect the funds, especially when we anticipate the funds will be $150,000 or more. My client just wants the funds protected and have them placed in my trust account. So we're asking the court to sign the order as presented.
Ms. Gibson, any response there?
Yes, Your Honor. Putting them in a joint account gives equal access to both parties. You had previously ruled for the home to be sold that each party be allowed access to some of those funds. Particularly because I will need access to some of the funds in order to move. And you said that you would reserve and consider that at the time when the home sells. Ms. Baldwin's accusation that I've documented or falsified financial records just isn't true. And it's also really easy to see if there's a joint account, if money's taken out, which person takes it out, where it comes out of. So there's no risk of money being moved without the parties being aware of it. It just makes sense to put them in a joint account. It can accrue interest during that time. Both parties can see where the money is so that I can just know that if the court does make a ruling that I am allowed access to those funds, that I can get immediate access to those, that I'm not trying to have to work through Ms. Baldwin's office, which whatever delay that may or may not incur, that I have funds available should the court allocate those to each party. So that's my only concern. And I guess just a clarification point, I don't know if it needed to be in the presentation order, that when the realtor comes out, if there are any costs to any sort of, not upgrades, but any sort of costs incurring to getting the home ready to sell, that those be split equally among the parties, that I shouldn't be solely responsible for those, as petitioner is still on the mortgages for the house, and they are the party that wanted the home sold and not myself.
Let me start and then I'll turn to you, Ms. Baldwin. So I guess as to the trust account, there are very, 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 very strict guidelines on attorneys' trust accounts. And frankly, the historical posture of this case, I think the trust account is the appropriate place for the funds. If there is an allocation of funds, which I did reserve and said I would be willing to consider to allocate funds, there should not be a significant delay because it's in a trust account versus a joint account. There was, I believe, a contempt that was found previously for on a respondent for essentially doing the thing that you're claiming you're worried about happening to you. So I am not swayed by that argument. So I think the trust account is appropriate.
Generally, because we do have a selected real estate agent, that agent will go through the home, make recommendations on what's possible, what's feasible, what's financially prudent. And then usually the parties work that out. So it's to both of their benefits to maximize the sale price. I'm not saying my client won't contribute, but the contempt that we have coming up next indicates my client doesn't have a lot of funds to do that with. And so I just don't think the court should address it. I have Ms. Evald's information. She readily communicates with me if there's some kind of repair or sort of curbside improvement, beautification. We can certainly talk about that. I just don't think it's properly before the court. So again, both parties are motivated to deal with improvements. Usually then the way we handle that is after the fact. Everybody provides receipts and that gets paid off the top. So I don't have any objections to those sorts of things. But again, those all need to be agreed on, things that Mrs. Ewald recommends. And so I don't think the court should address it today. I just don't think that I don't think it's necessary. It's not properly before the court. It's something that I haven't historically had a problem handling when both parties are motivated to maximize the sale price.
It sounds like they're a commitment to trying to work things out. If there are any bills or anything that, if there's a water heater on its last legs that needs to be replaced, whatever it is that's suggested, I think that can all be negotiated either outside of the court's purview or in front of the court if it comes to that. I am gonna sign the order regarding home sale as it's presented.
Yes, we did provide that. I'll note we didn't provide a full week's notice on that. If Ms. Gibson is requesting additional time, that's fine. I think this was intended to be presented at a prior hearing, but we had some intervening surprise things happen. And so this sort of fell by the wayside. So haven't received any objections to date, but she's had less than the full week.
Is there another issue that we need to address?
Yes, we're also before the court on contempt.
If I may, before you begin, Ms. Baldwin.
The debate over the money intensifies, with Miss Gibson emphasizing access and flexibility, saying she needs funds quickly for relocation and expenses. But the court doesn't just look at convenience, it looks at history. And that history matters.
Go ahead.
For the court. So I have been in the process for a while now of trying to obtain counsel. I had a scheduled consultation appointment with counsel that got unexpectedly rescheduled due to an illness. I had hoped to have representation for this hearing. I am set to meet with counsel later this week.
Baldwin, any objection to setting the contempt to 8-1?
Certainly do. Here's why. The contempt was originally scheduled for last week. Everyone understood that we were going to have that heard last week. That's why we put, the court will recall there was a restraining order. We put the restraining order on the same date because as the contempt filing, because that was already sitting last week before the court. And I said, I didn't care what judicial officer heard it. And Ms. Gibson said, I want to heard as soon as possible. So last week we come before the court, Ms. Gibson, then despite having filed a response, basically says, well, I don't want it heard, makes no mention of finding counsel, kicks it over to this week at her request for continuance. Here we are yet again. Again, she's filed her response. Nothing has really changed. Counsel may come in or may not come in. We don't know. But the reality is we're in a position where we've already had, this is the second hearing where we've come before the court on the contempt. Everything's filed. I think it's appropriate that my client receive relief. The children at this point are suffering very real consequences. And the idea that we would put it out is not reasonable. My client, because of how we time these things, my client's already waited a month to have this heard. The idea that it takes 6 weeks to get a pretty straightforward contempt heard isn't reasonable. So we ask that we go forward today.
All right, I do see, so Miss Gibson, you did respond. And the last hearing I was at, I do note Miss Baldwin's correct that there was a request for this to be heard as quickly as possible. So that was set on to the 11th, and then it was continued to today, the 18th. So given that this was filed the 12th of June, and we're at the 18th of July, and this is the third date that we've had since this has been filed, we'll handle this today. All right, so Ms. Baldwin, go ahead.
Thank you. This is a very clear-cut matter of contempt. This is for failure to pay daycare fees as apportioned by the order of child support. That is a child support obligation. When the court looks back at the record, you'll find that the court largely adopted Ms. Gibson's proposed statements about her income level and her proposed proportional share of the children's expenses. At that time and throughout the case, essentially until this contempt was filed, Ms. Gibson repeatedly told the court that she could afford to pay all of her obligations so that she could avoid having the house ordered to be sold. Again, and it wasn't just that she could meet all of her obligations, she could meet those obligations and refinance the house in order to be able to avoid it being sold. So she said that she could refinance and increase what she was paying. This is what she told the court she was able to do. Now she comes before the court and says, oh, I can't pay it all. Let me make $50 a month payments, even though the obligation is somewhere in the hundreds and hundreds of dollars. Let me just pay $50 and not pay anything more. So which is it? You can't have it both ways in essentially a 6-month period of time. Either you can make all your obligations or you can't. And the reality is that Miss Gibson will tell you whatever she thinks is going to get her what she wants on that day. I think it is notable that Miss Gibson previously had a second job. She quit that job. That's a job that is not considered in her current income as set for the purposes of child support. So the court did not assess her to have that, but she did have that historically. Again, it's undisputed. There's a court order for her to pay, that my client timely sent her the billings, and that she has not paid. Her claims that there are, I've made $50 good faith payments, that is not good faith. That is a please don't send me to jail, but it is absolutely, I'll pay what I want. So I'll just keep paying $50 so that you don't throw me in jail. She's not providing her bank statements. She's not saying, here's all the expenses I've cut at. Gee, I've cut my cable, my phone down to the bare minimum. I've cut this expense and that. There's none of that. It's sort of just, gee, I can't pay. I'm just going to throw my hands up and to say that that's an excuse. Again, notable from she only started making these payments, I believe in March or April. Children have been in daycare since January. And again, she's just making essentially a $50 payment toward what amounts to $1,000 bill. That is not good faith. When you look at her income, again, just blatant dishonesty with the court. She'll tell you what you want to hear the day you want to hear it to get her way. You look at back in December of 2022, she claimed, and we put it right in the reply, that her net income was $3,189. This is her statement. We are now 7-8 months down the road. If anything, she's gotten a raise, but now she claims that her net income is $700 less a month.
The court decides to move forward, and now the pressure is fully on. The father's attorney lays out a sharp argument centered on one key issue: contradiction. Miss Gibson previously told the court she could handle all her financial responsibilities, even suggesting she could refinance the home.
Well, that $700, there's just no evidence that supports a reduction of $700 a month in her income. No basis for that reduction. And if she had been applying that $700 a month toward the children's daycare expenses, we wouldn't be in this position. That would be good faith to say, oh, this is every bit of extra I have. So again, even within the course of 6 months, she's just talking out of both sides of her mouth. These claims that, oh, gee, I self-helped for offsets. Those are really throwaway arguments. First, latches in the sense it was never raised until my client said, hey, you owe this child support obligation. Never once raised in the more than year she says that obligation existed until my client asked for payment. So if it was a real obligation, she should have been asking for it from the minute the order was made. Two, if you're using basic law school contract principles, the order is construed against the drafter as to any ambiguity. This was drafted by her counsel at that time. And two, three, you can't self-help. This idea that, oh, well, I'll just offset these things is not appropriate. We do have 2 prior contempts in this case, one regarding finances, one regarding the parenting plan. This would be the third. There are very real consequences to the children of this action. The children have now been removed from daycare due to non-payment. That is a very real negative consequence that the children of this action now have to deal with, and that my client has to deal with, because he can't afford to manage everything on his own financially. The child support is a right of the children. And Mrs. is just saying, I'll do what I want. I'll pay what I want, sort of shrugging her shoulders at the consequences. And that is not appropriate. This is somewhat a disaster at this point because it takes so long to have these matters heard. It's really a disaster of Ms. Gibson's make. She's done something that has financially harmed everyone and is actively harming the children. Daycare spaces can be precious, and getting them back is a question mark on whether or not, even if she pays now, there may be now a waiting list where my client has to choose more expensive options because that's all that there is. Given this, the order only calculates arrears through June. That's fine. Arrears through June for the daycare obligation is $4,490, $318 of interest. I am asking for a substantial amount of fees of $3,500. That considers the set over from last week. That considers today, all the efforts to get her to pay. But it also considers the fact that when we dealt with the motions, the court had reserved previously sort of fees on the motions regarding the house. And again, when you're being blatantly dishonest before the court and saying, I can meet all my obligations and afford a refi increase, but that delayed the sale of the house, which would have provided funds for my client and would have freed up money because Mrs. could choose cheaper housing. She's really, again, created a financial disaster for these parties by being dishonest with the court about her finances. I'm asking for a civil sanction of $1,000. Again, when you have somebody just blatantly lying to you in a pleading where I can put captures of look at this and look at this, and these are the dates that she did it, and told the court one thing and then told the court something that's significantly different, that's sanctionable. It just is. And finally, cost of $750, or I'm sorry, cost of $75. Finally, because the court has ordered home to be sold, what I am asking the court to do is authorize that my client will be made whole any judgments that have been entered to date in his favor against Mrs. That will allow him to catch up all the daycare payments. And those would be then establishes against her community portion whenever that is later decided. I think that is relief that's necessary and appropriate. Again, my client needs these children to be in daycare. He needs to work. He works full time to support the children. So we need to be in a position where we're making appropriate use of those proceeds if and when they become available. Really a problem of Ms. Gibson's making. And frankly, the old adage, what a tangled web we weave, that is the position she is in. So at some point we have to deal with that. And I think that's today.
All right. Thank you very much. Ms. Gibson, your response?
Thank you, Your Honor. We're here today for something that I feel shouldn't even necessarily be in front of the court today. Ms. Baldwin is correct that I've been making weekly payments to petitioner. If you look at my financial declaration, that extra $700 is for child support that is coming out of my check now since petitioner has had the children. And at this point, I thought that things would have been different with all of the extra things going on with the children. I thought that I would be able to refinance the house and do those things under the assumption that what I was, told by the courts, this step needs to happen, this step needs to happen, this step needs to happen for the kids, that I would get the children back and potentially be getting child support payments again. That's clearly not happening at this stage. So as I showed in my financial declaration, I'm making...
Ms. Gibson responds by focusing on her financial reality. She explains that her income is stretched thin, with deductions and essential expenses leaving her with almost nothing. She describes cutting back wherever possible and making small payments as a sign of effort.
Payments to him in good faith because I'm already in the negative for all of my bills. I'm having to pay all the house payments. I have greatly reduced all of my bills as much as I can. I need a phone bill. That is the smallest phone bill that I could get. I cut all of my cable. I just have basic internet. I don't spend excess money on groceries. I don't spend money on myself. I can't afford to make these full payments at this point to petitioner and also keep a roof over my head or make my car payment so I can go to work. So I'm not quite sure what Ms. Baldwin or the court expects me to do. I can't do all of it. And then to talk to the point of Ms. Baldwin, I started making $50 payments to petitioner back in March. That was after months of trying to get this offset for petitioner still not paying his court-ordered obligation on the house, which is his half of the homeowner's insurance and his half of the property taxes. It's been addressed in multiple pleadings, so I didn't touch base on it too much in this response declaration. But back in November of 2021, Judge Scudder approved that initial separation of expenses. Then in March of 22, Ms. Baldwin and my attorney at the time, Ms. Winkles, had a whole hearing about it in front of Judge Scudder, who ruled that he wasn't changing any of those obligations. Payments still weren't made. It was advised to me when I had counsel that I could just, since I was able to afford.
Is way beyond the declarations and citing lots of hearsay. I've kind of let it go for a while, but at some point she needs to hold herself to her declaration.
Let's refocus onto this contempt. Ms. Gibson, I know in your responsive declaration, you alluded to a contempt you were filing. I don't know that you did file that contempt, so that's a little bit beyond what we're dealing with today.
Okay, Your Honor. Yeah, I'm having difficulty trying to figure that out since I don't have counsel. I guess what I would say is I've been making these good faith payments, even though I don't have the money to make those payments. Petitioner lives at home with his parents. To my knowledge, he doesn't pay rent. He doesn't pay the mortgage. He works full time. He makes twice what I make. His mom is retired and stays at home and watches the children even before he established them in daycare, which is a daycare that he put them in that I wasn't notified about until months later. In our parenting plan, we still have joint decision making, and I'm not being made aware of where my children are seeing doctors, where they're going to daycare, any of this. So I would just ask the court not to find me in contempt. I'm doing the best that I can with the money that I have, because at this point, it's either I pay the mortgage or I pay childcare. And I don't know what counsel or the court want me to do, and I want to provide for my children. I'm just doing the best that I can right now.
Right. Thank you, Ms. Gibson. Ms. Baldwin, anything else?
Just briefly, paternal grandparents have been gracious in their efforts, but they are not obligated to be full-time daycare providers for free for Ms. Gibson because she doesn't want to pay. They attempt to sort of muddy the water of, gee, all these terrible things have happened. A, we dispute those, and B, they're not relevant to today. But the reality is we have somebody who isn't providing you with bank statements, isn't providing you in advance of sort of hearing my argument of the things that she's cut out of spending. And again, we have a court order on what her obligations are, and she's getting the bills and just shrugging her shoulders. It's not appropriate. These children are facing a real consequence, or at this point have faced that consequence, are in the middle of that consequence for her non-payment. Payment should be made. We're asking for the arrears and these fees and sanctions as I've ordered. And then finally for the judgments to be apportioned out of Ms. Gibson's any award that she has, but paid immediately from the sale proceeds of the house, so that hopefully the children can return to daycare shortly.
All right, thank you. So I'm looking at the temporary order of child support that was entered in December of 2022 by Judge Scudder. And it does appear that Judge Scudder deviated downwards from the state, essentially the calculation, the standard calculation for child support, not only just in the standard calculation, but then took off another $250. I'm assuming there's a reason for that, but there's a transfer of $552 a month for child support, and then a 60-40 allocation for uninsured medical costs, work-related daycare, preschool, and the like. So 60 to Mr., 40 to Mrs. That order is cut and dry. I understand Ms. Gibson has concerns with the previous order of the court and the mortgage, or excuse me, the home insurance, and it's escaping me now, but I understand her issue. That's not before the court today. I also very much sympathize with Ms. Gibson's position. If everything, assuming everything she is saying is accurate, that it is a difficult situation to be in when you feel you don't have the finances to cover one versus the other. So frankly, I think it was appropriate to make the decision to sell the home, because I don't know how Ms. Gibson, given the situation she's claiming to be in monetarily, how that would have ever worked. And two, this is a pretty straightforward child support order. And it appears as though while there's attempts, there's also a failure to be able to provide those. And Unlike a lot of cases, it does appear that this has already negatively impacted the children in this case with their removal from any daycare programs, because there's just no money to pay for that, and the lack of payment from the respondent. I am going to make a finding of contempt. The back costs, the interest, standard costs, so the $46.90, the $319 interest, $70 in costs, I'll adopt all of that. The civil sanction, I'm going to reduce to $500, and the fees I'm going to reduce to $1,500. I don't expect Miss Gibson to be able to pay that money. I want her to stay as up to date with the support order that sounds like it's being garnished, and make as many payments as possible. But ideally, if the house can get sold, I think it's appropriate for those to be just subtracted from her side of any award for the return on the house. We'll set presentation to the first, and then what I don't want is a lot of transfer payments back and forth. So we'll can look at any offsets if and when there's a potential new contempt filed by either side, and the ruling of the court. We'll enter that order.
Only request is at this point, because the children have exited daycare, it is a set sum that she owes. We'd ask that we just be able to update that total amount of what she owes through the day the children exited care.
That's appropriate. So if those numbers are different on the first, we'll enter the final.
When the judge delivers the decision, the reasoning is direct and balanced. The court acknowledges that her situation may be difficult, but the support order is clear, and it wasn't followed. More importantly, the children were directly affected, and that carries weight. A finding of contempt is issued. However, the court also reduces the penalties, recognizing that overwhelming financial pressure won't fix the problem. Instead, a practical solution is put in place. What she owes will be taken from her share of the home sale. It's a controlled outcome, but also a firm message. The court is no longer focused on explanations. Moving forward, compliance isn't optional, and the priority is making sure the children aren't impacted again.